Lesson 20, AP Government. Civil liberties. Civil liberties are individual legal and constitutional protections against the government. These should not be confused with civil rights. The civil rights chapter is going to deal with movements by groups such as African Americans, Native Americans, and women to protect their civil liberties that have been not equally protected based on some specific classification that the group falls under. The objective behind civil liberties is limited government. Our civil liberties are set down in the Bill of Rights, and the Bill of Rights was a precondition for ratification. We studied this in previous chapters. This is how the Federalists were able to persuade enough of the Anti-Federalists to get the Constitution ratified. The Bill of Rights is the first 10 amendments, so they were ratified in 1791. They were influenced by the experience of British rule. This perfect example of that is the Third Amendment, which has to do with quartering, because British soldiers were being quartered in people's homes during this period of time when George III was cracking down on the colonies, which of course led to the American Revolution. Thorny issues in civil liberties. People are supportive of individual rights in theory, but they are less supportive in practice. A good example is free speech for racists. Neo-Nazis marched in Skokie, Illinois, a suburb of Chicago. It's a Jewish suburb, and think about it: neo-Nazis marching in a Jewish community. Obviously, that is a difficult one for people to accept. It becomes very hard for people to accept the idea that the courts are going to protect the rights of neo-Nazis to basically be obnoxious. It's especially difficult when civil liberties are in conflict. An example would be the free press versus the fair trial, these civil liberties issues. The example that is often used is the Shepard case. This is a doctor. His case was sensationalized. People made a big fuss out of it. The press really kind of reported every rumor known to man about it, and it was found that basically Shepard was not able to get a fair trial with an impartial jury, that the jury had, the possible jury members had way too much information about the case. Some of it wasn't even true. It also can be difficult when facts are open to interpretation. I think a classic example would be abortion. I think one of the big issues behind abortion is defining life, defining when human life begins. There are scientific explanations, religious explanations, and philosophical explanations for when life begins, and if they all were the same, it would be much simpler. I think because people do not agree on that particular issue, that's why the abortion issue is so controversial and so difficult for people to come to agreement on. Limited government. The Bill of Rights is written to restrict the powers of the federal government, the central government. It did not apply to the states. They had their own Bill of Rights, and in fact, it was one of the arguments that the Federalists made when the Anti-Federalists were arguing for a Bill of Rights. They said, well, the states have them already. There's no reason for a Bill of Rights. Because from their perspective, if it didn't say the federal government could do it, you can't do it. However, they finally compromised and added a Bill of Rights. The case of Barron versus Baltimore in 1833, this is several decades after the ratification of the Constitution, it confirms the Bill of Rights only applies to the federal government. And that is the understanding of the Bill of Rights that will be in place for basically about a century. First Amendment. Look at the First Amendment in the Bill of Rights, and remember that it guarantees free expression. The way I remember this is RAPS, R-A-P-P-S, religion, assembly, petition, press, and speech, R-A-P-P-S. There you go. Pretty easy to remember. Incorporation Doctrine. The rationale for extending the U.S. Bill of Rights protections to the states is that the 14th Amendment, one of the Civil War amendments, one of these amendments designed to make sure that the slaves who have been freed will be protected somewhat against abuse by the states. The 14th Amendment guarantees privileges and immunities of citizens. It guarantees due process and equal protection under the law. and it's explicitly applied against the states. And this is what judges will be using to incorporate or add protection for various rights in the U.S. Bill of Rights, protection not only from the federal government, but protection from the state governments. So incorporation begins with the Gitlow versus New York case in 1925, has to do with free press and free speech. The argument in this clause here, this quotation here, it says, fundamental personal rights and liberties protected by the Due Process Clause. So the argument is that rights and liberties are protected by due process, the Due Process Clause in the 14th Amendment, and that's how they're going to use this as the doorway to extend all of these rights in the Bill of Rights into protections against state governments. Most of the Bill of Rights will be incorporated in the 1960s by the Warren Court. There's a smattering of cases before that, starting in 1925, but in the 1960s, this very activist court, the Warren Court, will incorporate a bunch of civil liberties. The Second Amendment has been incorporated somewhat since the publication of your text. We'll get into that here in a second. The Third and Seventh have not. Grand jury requirements in the Fifth have not been. And some disagree with Incorporation Doctrine. With the Incorporation Doctrine in your textbook, it brings up Edwin Meese, who argues for disincorporation. He has a rationale explaining that the 14th Amendment should not be applied the way that it's being applied, and obviously the courts have not agreed with it. The Second Amendment, it's the right to bear arms. The old interpretation that a lot of people assumed the courts would eventually validate, and they didn't, is that the right relates only to militias, that if it doesn't have to do with the state militia, you don't really have any right to bear arms at all. Recent cases confirm that you have a personal right to bear arms. It is not an absolute right. You don't get to wave a bazooka around town when you feel like it. So don't get too happy if you like explosives. Criminal rights. The Fourth Amendment establishes that for you to be searched, for your home to be searched, a judge needs to sign off on a search warrant. Probable cause needs to be shown that there's a good reason to be searching your home or your person. Only in really extreme cases can a police officer just knock your door down and look around. Basically, if he hears someone screaming, "I'm going to kill you with this knife," and then hears more screaming from someone who's obviously scared, maybe they could break down the door. That would be decided later on by a judge. But generally speaking, they have to go through a lot of paperwork to get that done. Fifth Amendment, due process is the big thing here. Due process, which basically argues that the government has to follow its own rules. Then double jeopardy, they can't try you for the same crime twice. If they found you not guilty the first time, it's done. The right against self-incrimination, you don't have to testify against yourself, and just compensation is not really a criminal right, but it's in the Fifth Amendment. Basically, if they take your property to build a bridge, they have to pay you a fair amount for what your property was worth. The Sixth Amendment, you get to have a speedy public trial with a fair jury and a proper defense, which includes the ability to hear witnesses, call witnesses, and know what the evidence is against you, and be able to answer that. The Seventh Amendment is a right to a jury in civil cases of over $20, and that has not been incorporated. I probably shouldn't have even bothered to put it in the list, but I did, so there you go. Eighth Amendment, no excessive bails or fines can be brought against you by a judge, and no cruel or unusual punishment. It's the extreme amendment. Now, freedom of religion. There are two religious clauses in the First Amendment. The Establishment Clause, which says Congress shall make no law respecting the establishment of religion. There shall be no Church of America. Unlike England, that has the Church of England, there's no Church of America. And the Free Exercise Clause, the right to practice your religion. Now, the debate over the Establishment Clause is this. Jefferson argues there's a wall of separation that prohibits any support of religion. Now, remember Jefferson wasn't even a framer. That's kind of can be important when you look at this. Now, advocates of parochial aid to parochial schools argue it does not favor a particular religion. So issue 1 is parochial aid, in and of itself constitutional, and issue 2, Roman Catholic schools get the most aid, so if we're giving aid to parochial schools, are we, unfairly aiding one particular denomination? the courts decided this issue was with the Lemon laws from Lemon versus Kurtzman. There are 3 laws in this court decision. Don't get this confused with actual Lemon laws that have to do with what states do when people buy a bad car or something like that. Parochial aid must have a secular purpose. It may neither advance nor inhibit religion, and it has to avoid excessive entanglement. So if you get past the first 2, but still this involves the government being way too cozy with the parochial schools, the religious schools, way too involved, then it's going to be turned down, rejected by the courts. Zelman versus Simmons-Harris is a case from 2002. It says vouchers to pay tuition at religious schools are okay. This is like, when vouchers are given to pay tuition at private schools. If a private school happens to be a religious school, it's okay. School prayer. Voluntary prayers or Bible recitations as part of a class they violate Establishment Clause. Engel versus Vitale, School District of Abington Township, Pennsylvania versus Shemp are all cases that deal with this. Engel and Abington argue, that the courts found that states must be neutral with religion, and this is an issue where the majority of the public disagrees with the court, and that's why there's so many court cases about it. People trying to do prayers in football games, all sorts of things, and the courts have basically said if it's led somehow by the school, if it uses the school speaker system, it can't be done. Fundamentalist Christians. The fight for school prayer and creation science is where they're at. They've lost some cases. They've won some cases. Wallace versus Jaffrey, 1985, rejected voluntary school prayer. Edwards versus Aguiar, 1987, rejected requirements to teach creation science as an alternative to Darwinian evolution. Basically, Darwin was that there wasn't enough science and creation science to be teaching it in a science class. Lynch versus Donnelly, 1984, and County of Allegheny versus ACLU, 1992, established, though, that religious scenes can be set up on public property. You can have like a menorah and a cross and a Christmas tree all up around Hanukkah and Christmas time, that kind of thing. But it can't be like there is one God and His only begotten Son is Jesus. You can't have something like that up on public property. Free exercise. Laws may not impose special burdens on religion, but no religious exemptions from laws binding all other citizens. So you can, there are a few exemptions, but generally speaking, you can't use your religion to get away from the law that everybody else has to follow. Some cases are difficult to settle: conscientious objection to military service, refusal to work Saturdays, like the Seventh-day Adventists, refusal to send children to public school beyond 8th grade, and refusal to seek professional medical care for sick children. And that last one has come up some, and usually people are going to jail for abusing their child when they refuse to take their child to a doctor when they're really sick and then something horrible happens to their kid. So free exercise can sometimes conflict with other values. In Wisconsin versus Yoder, 1972, there's a compromise made. The value of kids getting a quality education versus religious rights here, free exercise rights. Amish parents, this is the compromise. Amish parents can take their kids out of school after 8th grade, but they have to be in school to 8th grade or through 8th grade.